Hello everyone, this is Urvashi Chauhan. Welcome to Courts Today by Livelaw, where we bring you the latest developments from all courts across India. Let us start. Starting with the Supreme Court, which today heard human rights activist Teesta Setalvad's plea against the Gujarat High Court's decision which denied her regular bail in connection with an FIR lodged against her by the Gujarat police. The FIR is for allegedly fabricating documents to implicate high government functionaries in relation to the 2002 Gujarat riots. Setalvad was today granted regular bail by the Supreme Court. A bench comprising Justices B.R. Gogoi, A.S. Bopanna and Dipankar Datta quashed the Gujarat High Court's order, observing that the High Court's observations were perverse and contradictory. Senior Advocate Kapil Sibal appeared for the petitioner and Additional Solicitor General S.V. Raju appeared for the state of Gujarat. You can visit our website at livelaw.in to read in detail about the interesting arguments made by the senior advocates. The law regarding sedition has been a topic of debate and discussion for a long time now, with critics arguing that it is misused to suppress dissent and curtail freedom of speech. As you know, that the law of sedition covered by Article 124A of the Indian Penal Code has been kept in abeyance as per Supreme Court's direction till the Union government reconsiders the provision. Assamese activist turned politician Akhil Gogoi has filed a writ petition in the Supreme Court of India challenging the constitutional validity of the offence of sedition along with related offences which employ similar logic of sedition in as much as they entail the same ingredients. You must have heard his name as he has had extensive run-ins with the law, especially because of his involvement in the anti-government protests such as those against the NRC and CAA, for which he was also arrested and booked for criminal conspiracy, sedition, and various offences of the UAPA. The petitioner claims that he is an object of prejudice because his dissenting speech is always seen as a symptom of some deep-rooted conspiracy, although he has never indulged in any violence. It is further emphasized that mere calls for bandhs are equated with economic blockades that intend to systematically destroy the economy. Relying on the Supreme Court order to keep the law in abeyance, the petition argues that not just the offence of sedition, but also the logic, the ingredients that made up the provision also require judicial review. The next update is with respect to another topic which is also much debated in our country, that is marital rape. So as you know that marital rape is not explicitly recognized as a criminal offence in India. The second exception to Section 375 of IPC clearly states that sexual intercourse by a man with his own wife who is above 18 years of age is not considered rape, even if it is without her consent. This exception is based on the belief that marriage implies consent to sexual activity and criminalizing marital rape could potentially disrupt the institution of marriage. However, various women rights groups, activists and legal experts have been advocating for the criminalization of marital rape in India. The constitutional validity of Exception 2 to Section 375 has been challenged before the Supreme Court on a batch of petitions, and today the Supreme Court has stated that it will consider listing the pleas. The batch of petitions were to be listed on 21st March this year before bench of CJI Chandrachud, Justice P.S. Narasimha and Justice J.B. Pardiwala, but could not be listed due to Justice Pardiwala's absence. It was then to be listed on 9th May, but again was not. Stay tuned for regular updates on the issue. The Supreme Court has posted to 5th September a bunch of petitions relating to the effects of electromagnetic radiation generated by mobile phone towers. A bench comprising Justices A.S. Bopanna and M.M. Sundaresh was hearing appeals arising out of a Rajasthan High Court judgment which upheld the government notification prescribing a minimum distance of 500 meters for mobile towers from schools, playgrounds, hospitals, etc. So, Rajasthan state government considered recommendations of the Inter-Ministerial Committee that the installation of mobile towers in schools, colleges, playgrounds and hospitals and on the place within 500 meters from the jail premises be prohibited and removed. Therefore, it framed the bylaws in accordance with it in August 2012. Writ petitions were filed by Cellular Operators of India before the High Court to quash it. The court held that provisions were regulatory measures considering the health hazard and other aspects of EMF radiations from mobile towers, and such regulatory measures could not in any manner be said to be arbitrary. Aggrieved by the said order, the petitioners filed an SLP before the Supreme Court. While adjourning the matter, Justice Bopanna in a lighter vein also said that lawyers who are opposing mobile towers should deposit their mobile phones before arguing. An important observation has come from the Supreme Court regarding the POCSO Act. The Supreme Court has observed that school transfer certificate and extracts of the admission register cannot be relied on to determine age of the victim in a POCSO case. The court was considering an appeal filed by a man who was convicted under the POCSO Act. In this case, the trial court had relied on a school transfer certificate. Further, the doctor had deposed that the age of the said girl would be more than 18 years and less than 20 years. But the High Court rejected this evidence, saying that the precise date of birth was available from the school records. And so the appropriate age estimated by the medical expert would not be the determining factor. But the Supreme Court has considered the High Court's view to be incorrect and erroneous. The bench of Justices S. Ravindra Bhatt and Arvind Kumar noted that wherever the dispute with respect to the age of a person arises in context of him or her being a victim under the POCSO Act, the courts have to take recourse to the steps indicated in Section 94 of the Juvenile Justice Act. So let me tell you what this section is about. Section 94 indicates that the date of birth certificate from the school or certificate of matriculation has to be firstly preferred, in the absence of which the birth certificate issued by the corporation or municipal authority or panchayat is to be preferred. And only in the absence of these documents, the age is to be determined through an ossification test or any other latest medical age determination test. Thus, here the court said that the medical result of the ossification or the bone test was the most authentic evidence. Now and then we hear allegations of fake encounters carried out by law enforcement agencies or security forces where individuals are allegedly killed without proper legal procedures or due process. Human rights organizations and activists have raised concerns about the lack of accountability and transparency in such cases. These have been a subject of public debate and have prompted calls for reform in the criminal justice system. The Supreme Court has issued notice on a plea filed against the Guwahati High Court's refusal to entertain a PIL filed in 2021 seeking independent investigation of alleged fake encounters in Assam. The petitioner claims that the PIL was disposed of with no cogent directions, despite the facts and materials placed before the court. The petitioner had inter alia sought the designation of a human rights court in every district of Assam. The petitioner argues that despite overwhelming number of police encounter incidents in over a year, the records placed before the High Court show that the state did not comply with the 16 guidelines for investigation of illegal encounters as given in the PUCL case. In another update, the Supreme Court has sought the response of CBI in the pleas challenging grant of anticipatory bail to Lok Sabha member Y.S. Avinash Reddy by the Telangana High Court. A bench of Justices Sanjeev Khanna and Bela M. Trivedi was hearing a batch of pleas connected with the Vivekanand Reddy murder, including a petition filed by his daughter Sunitha Reddy challenging the pre-arrest bail granted to Y.S. Avinash Reddy, an MP from Telangana's ruling YSRCP, and her cousin. The top court also directed the central agency to file in a sealed cover a copy of the charge sheet as well as that of original case files pertaining to the murder of Y.S. Vivekanand Reddy. You must have seen the recent viral video on social media of the Sidhi urination case. Pravesh Shukla has been accused of urinating upon a tribal man. He was thereafter arrested and booked under various sections of IPC, SC/ST Act, and was also booked under the National Security Act, that is NSA. After his detention, his wife Kanchan Shukla filed habeas corpus plea challenging the invocation of NSA. The plea avers that the detention order passed by Sidhi district collector does not indicate the right to make a representation against the order. Now, the Madhya Pradesh High Court has sought the state government's response in the plea. A notice was issued to the state government by a division bench comprising Chief Justice Ravi Malimat and Justice Vishal Mishra, seeking its response in 2 weeks. Stay tuned as the matter will next be heard on 1st August. The Bombay High Court has stayed the district magistrate's order restraining people from offering prayers at a mosque in Jalgaon and has allowed religious prayers to continue until the next hearing, which is scheduled after 2 weeks. The current situation arose from a complaint submitted by the Pandavwada Sangharsh Samiti (PSS) to the district magistrate in May this year. PSS has claimed that the mosque in question resembles a temple and accused the local Muslim community of encroachment. On the other hand, the trust maintaining the mosque claims to possess records providing the existence of the structure at least since 1861. Further, on 11th July, the DM issued an interim restraining order and directed the Tehsildar to take charge of the mosque. Thus, the trust approached the High Court against this order. Justice R.M. Joshi of the Aurangabad bench observed that prima facie, the DM passed the order without being satisfied that there is likelihood of breach of peace, and accordingly, the order has been stayed. The matter has been posted for further hearing on 1st of August. The last update for today is in an intellectual property matter. Those of you who are involved in creating visual content, social media graphics, posters, flyers, etc., must have used Canva, an Australian multinational graphic design platform. The Delhi High Court has restrained Canva from making available its present and record feature in India in a patent infringement suit filed by RX Prism Health Systems Private Limited. Justice Pratibha M. Singh also directed Canva to deposit 50 lakh rupees with the Registrar General as a security for RX Prism's claims for past use of the infringing feature in India. This was done considering revenue and sales figures of the users who used the feature in the country at least once till 30th June 2022. The court said that the plaintiff had made out a case of infringement, especially by a mapping of claim charts, and that the defendant had been unable to make a credible challenge to the plaintiff's patent. Thank you for joining us. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share, and subscribe and support us.